That's it. I am out of material. I want to now turn it over to our gracious host. Thank you for inviting us. This is Marita Butzbach from Lang Management over in Palm Beach County. Marita, take it away, please.
Good afternoon, everyone. Thanks so much for joining us this afternoon. I know this is a very important topic to managers and board members as a whole to ensure that your notice requirements, elections, and voting procedures go as well as planned and are according to the state statutes. We're very grateful that Peter is going to do this seminar for all of you this afternoon. And Jeff, thank you so much for setting all this up. We have a lot of our associations who are with K. Bender and Rembaum, and I can tell you from associations that I'm working with, they respond very quickly, they respond very intelligently, and we really appreciate working with them. We do association matters with them once a quarter. We'll be sending out information on those. That again, those are informational. While these are for CEU credits and your credits as board members today, those association matters we try to do them based on whatever is the latest topic or issue going on, so that we can keep you informed. You know, I'm a firm believer that education is power. So we will send all of these out to you, whether you are our clients or not. I know there's a lot of attorneys who are offering these CEU courses, but I will tell you, Kay Bender and Rembaum does not charge for them. You don't have to be a client of theirs. And they were gracious to do this with us today. Many of our board members asked for the classes for their credits. So we set this up for all of you today, and we hope you enjoy it. And with that, Peter, I'm going to turn it over to you.
Thank you, Marita. I appreciate that. All those kind words. Hi, everybody. And thank you, Jeff, as well. As Jeff said, I am Peter Mullengarden. I'm an attorney here at K. Bender Rembaum. And there's a little bit about me, very exciting. I am a Florida Bar board certified specialist in condominium and plan development law. Our firm actually has, I think there's 8 or 9 of us right now who are Florida Bar board certified. Danielle Brennan earlier today, she's also board certified in same as I am. I have been doing this a long time. I have been in the community association law business my entire career. In the beginning of my career, I worked with associations in Florida, South Florida, and then I actually relocated for about 6-7 years to the Washington, D.C. area, where I drafted condominium and HOA documents for developers. Anyone from the D.C. area, Silver Spring, Maryland, Montgomery County, Bethesda, those areas. That's where I worked. Then I came back to Florida after that brief hiatus in Florida in 1992. And I've spent the rest of my career since that time here in beautiful South Florida representing associations. K. Bender Rembaum, this is what we do. We represent associations. That's like 99.9% of our business. And we consider ourselves to be a full service community association law firm. Okay, enough about that, and on to what you really came here to listen to, hopefully. Okay, so what are we doing here besides spending an afternoon watching me and everything? Well, in addition to the initial curriculum course that all board members must take when they are either elected or appointed to the board, a director of a homeowner association. By the way, we're going to be talking about HOAs today. I will occasionally segue into condos just for comparison's sake, just to show you some of the differences between HOAs and condos, because I know from my experience, particularly when we get to elections and meetings, sometimes there's some confusion because the condominium law seems to dominate everyone's thoughts so much that oftentimes it inches its way into the HOA stuff, not necessarily because it should, but just because it just does. But anyway, so in addition to taking the initial course, if you're a director of a HOA that has fewer than 2,500 parcels, then you have to do at least 4 hours of continuing education annually. If you're director of a really large association that has 2,500 or more, as opposed to fewer than 2,500, then you must complete 8 hours of continuing education annually after you take that initial course, in the subsequent years you serve on the board. So membership meetings. Every association must hold a meeting of their members annually. Typically, that is the only membership or lot owner meeting you're going to have. Not necessarily, but for a lot of associations, it is. Okay. You must hold that meeting pursuant to or in accordance with your documents, typically the bylaws, which usually will specify the date, time, and place of the meeting, or otherwise address, how or when the annual meeting must be held. And again, the election of directors must be held at or in conjunction with your annual meeting. Like I said, oftentimes that is the only membership meeting because that's the meeting that you have the election. Now, there can be other meetings, which are special membership meetings. So special membership meetings refer to meetings of the membership other than the annual meeting. So when do you have those? Well, you have those typically when called by the board or when called pursuant to a petition of at least 10% of the voting interest of the association, if your documents are silent, and typically they're not, okay, or pursuant to the percentage of owners, which is required pursuant to your bylaws. And most bylaws will have a section, a provision regarding special membership meetings and indicate how many owners are required to petition or request a special meeting of the owners. And typically they also have to indicate the purpose of that meeting or purposes. Agenda. Okay. Interestingly, unless your documents otherwise provide, statutorily, the notice of the annual meeting does not need to set forth the agenda or the purpose of the meeting, but quite frankly, I recommend that you do so anyway. Okay. If your document's required, obviously you must. Currently, the statute doesn't. However, for a special membership meeting, okay, pursuant to statute, and when I say statute today, typically I'm referring to Chapter 720 Florida statutes, which is the statute that governs the operation of HOAs, homeowner associations. So for special membership meetings, the notice of your meeting must include the description of the purpose or purposes for which the meeting is called, and then the business at that meeting is then limited to that purpose or those purposes set forth in the agenda on the meeting notice. Notice requirements. All notices must have the date, time, and location of your meeting. Now, if your bylaws are silent, and most are not, but if your bylaws are silent with respect to notice to the membership of a membership meeting, then that notice must be mailed, delivered, or electronically transmitted to all the owners not less than 14 days before the meeting. And we're going to talk about electronic notice in a second. Evidence of compliance with that 14-day notice requirement must be made by an affidavit executed by the person providing the notice, which must be kept with the association's official records. So typically that's going to be an affidavit of the secretary, perhaps of the management agent, but the person who is basically has provided that notice to the owners, that 14-day notice. The notice for these membership meetings must be mailed or delivered to the address identified as the owner's mailing address in the official records of the association, or if it's sent by electronic transmission, if the owner has consented to that, then to that address. When I say must consent to it, electronic notice, which is either notice sent by email, or for those of you out there who still use fax, by facsimile, the owner must agree in writing to receive their notices in that manner, either by email or facsimile. And that consent can be revoked at any time by the owner. And if it is revoked, then you have to go back to hard copy notice to that owner. Electronic notice requirements. Again, the association may also provide notice of any meeting by electronic transmission, email or fax, as I just said before, to any owner who has consented to receive notice in that manner, and provided the email address or fax number to the association for that purpose. Those email numbers, those facsimile numbers must be removed from your records if and when that member, that owner revokes his or her consent to receive notice by electronic transmission. However, the association is not liable for inadvertent disclosure or erroneous inadvertent disclosure of that email address or fax number to others. But quite frankly, you should try in good faith and to the best of your ability to not be disclosing email and fax numbers to other owners which have not been consented to by the owner as their email, as their address for receiving notices, because they're privileged. If an owner has consented to their email address being used for notices, then that email address is available to other owners upon request. Now, the last bullet point there, electronic transmission may not be used as a method of providing notice of a meeting called in whole and part for the purpose of recalling a director. And I'm sure nobody listening to me will have to worry about that. Notice requirements. In addition to sending out notice to the owners, the association may, by reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and agenda on a closed-circuit cable television system serving your association. The notice and agenda must be broadcast in a manner and for sufficient continuous length of time so as to allow an average reader, whatever that is, to observe the notice and read and comprehend it of the entire content of the notice and the agenda. So don't just flash it for 2 seconds like some subliminal message, okay? It has to be up there long enough for an average person to be able to read and understand it. Now, by January 1st of last year, 2025, every association that has 100 or more parcels, and parcels is the statutory word for lots. So when you see parcel, just think lot. So by January 1st, 2025, any association with 100 or more lots was required to post notice and agenda of every members meeting, every scheduled members meeting, at least 14 days before the meeting, posting it on your website or your app. The notice must be posted in plain view on the home page of the website or your app, or on a separate subpage of the website or app labeled notices, which is conspicuously visible and linked from the home page. You must also post on, again, website or app, any document to be considered and voted on by the members at a membership meeting, or any document that's listed on the agenda. Those documents, if any, have to be posted at least 7 days, post on your website at least 7 days before the meeting at which that document or information is going to be considered. How about owners' right to participate? And of course, they do, pursuant to Chapter 720. So owners have a right to attend all the membership meetings and to speak at any meeting with respect to or with reference to all items that are open for discussion and all items that are included on the agenda. Remember that for special meetings of the membership, you can only address items that are on the agenda. Notwithstanding any contrary provision in your documents, an owner has a right to speak on any item for at least 3 minutes. The association may adopt, and I actually encourage you to do this, even if your meetings run pretty smoothly. This is a way just to try to ensure that they do run smoothly. So the association may adopt reasonable rules governing the frequency, duration, and other manner of owner statements, which rules must be consistent with what I just mentioned above. Membership meetings must be held at a location accessible to a physically handicapped person if it is requested by a physically handicapped person who has a right to attend the meeting. Finally, any owner may video or audio record membership meetings. The board may adopt reasonable rules governing the taping of meetings. Now, back in the old days, because I'm old, I admit it, but back in the old days, we used to have people come in with, oh my God, lights, cameras, almost camera crews. These days, everyone records by what? Their cell phone. Okay, so, but you can still adopt reasonable rules, such as you can't move around the room while you're doing your recording, or you can't walk into people's faces, which has happened to me while I'm speaking, while they're doing the recording. So again, you can adopt reasonable rules, even that you announce beforehand that you're going to be recording, so that people know that it's being recorded. So again, reasonable rules can be adopted with respect to the recording, but you can't stop people from recording. How about quorum? This is something actually now is completely different than condominium associations. And under the Homeowner Association Act, unless your documents, typically your bylaws, have a lower number, okay, then a quorum is 30% of the total voting interest of the association. That constitutes a quorum. And that means basically represented in person or by proxy, assuming your documents do not prohibit proxies. So again, the quorum requirement, 30% or lower if your documents have a lower quorum percentage or quorum requirement. How about making decisions at these meetings? Unless otherwise required by law or your governing documents, decisions at a membership meeting that require a vote of the owners, a vote of the members, must be made by the concurrence of at least a majority of the voting interest present in person or by proxy at a meeting at which a quorum has been obtained. In other words, a majority of a quorum. So what does that mean? That means if your quorum is 30%, okay, and you've barely reached the quorum, but you do have a quorum, then it's a majority of that. But let's say you have a great meeting and you have huge attendance and you have, 60% of the people are there in person or by proxy. Now you would need a majority of that 60% or whatever the percentage is. So this is a sliding scale. But if your documents, for example, require a specific vote for a certain action, such as an amendment to your declaration or amendment to your bylaws or something like that, and your documents say you need, let's say, 2/3 of all the membership or all the voting interests, then that's the vote you would need, not a majority of a quorum. So you really got to check your documents when you're voting on any particular issue to see what is the voting requirement for that matter set forth in your governing documents. Very, very crucial. Speaking of proxies, okay, unless otherwise provided in section 720.3068 or in your governing documents, members have a right to vote in person or by proxy. So check your documents out for any limitations on proxy voting. Again, typically that would be in bylaws. To be valid, and what is a proxy? I guess I should mention that real quick. A proxy is when I, Peter Mullengarden, I can't be at the meeting, so I am going to authorize, let's say, Marita, that she is going to vote for me. Okay, so I will name her as my proxy. So basically, she's going to vote in my stead at that meeting. She is, in essence, my proxy. She is my proxy holder. Okay, but to be valid, the proxy that is issued must be dated, including the date, time, and place of the meeting for which it's being issued or given, and must be signed by the authorized person who executed the proxy, typically the authorized voting representative or voting member owner for that lot. Now, a proxy is only effective for that meeting that is specified for. So a proxy is only effective for the specific meeting for which it was originally given, and any lawful adjournment of the meeting, however, it expires 90 days after the meeting for which it was originally given. But this 90 days, just a little pro tip here, okay, gives you a potential advantage. If you're trying to, let's say, pass an amendment to your declaration, and your amendment needs, let's say, 2/3 of all the owners to approve. Again, this is just hypothetical. I don't know what your documents say. I don't have your documents in front of me. So hypothetically, if your declaration needs a 2/3 vote, and you're in that meeting, and you can actually look at the proxies ahead of time, and you know how many proxies are there, you know how many people are there in person, and you know there's no way we're going to get 2/3. We only have 51% of the people here. So even if everyone voted yes, it's not going to pass. Because the proxy is good for 90 days, rather than counting the votes and saying, oh, it failed, you could basically ask for a motion to continue that meeting to be reconvened X days in advance or X days in the future, not more than 90 days, reconvene the meeting, solicit more proxies, and try to get to that 2/3. So that you had that 90-day period in which to adjourn, not finally adjourn, but adjourn to be reconvened. So that 90 days can be used as a mechanism to gather or garner more votes. But I would urge you to talk to your attorney. I'm not shilling here for lawyers today, but I would urge you to talk to your attorney to, see if this is a mechanism that would fit for you for that particular meeting. Now, a proxy is also revocable at any time by the person who executes it. Okay. So if I give my proxy and say, yeah, I'm going to show up, I can revoke it in writing. Now, a proxy holder can appoint in writing, if there's a power of substitution on the proxy, to act in his or her place. So let's go back to my original example. I gave my proxy to Marita. Marita finds out she has Marlins tickets to that night. She really can't make the meeting. I'm joking, Marita. You probably would not skip a meeting for a Marlins game.
Not for a Marlins game, no.
But, maybe for a Yankees game, right, Jeff? So anyway, or Mets for you.
There
So
you
you
go.
can't make the meeting for whatever reason. You're sick. You can actually substitute someone else in that power of substitution, and now that person is my proxy holder. So in essence, I've given the proxy to Marita. I've also given her the power to substitute someone else to be the proxy holder if she cannot attend the meeting. Okay. And I've seen it used. I've seen it used actually many times. A copy of the original proxy can be used if a complete reproduction. So I got this question a lot in the past. What if the proxy is not the original? That's okay. As long as it's a complete reproduction of the proxy, including, dated, the signature, doesn't have to be the original, can be a photocopy, can be a scan and a copy from that. Does not have to be the original.
So Peter, before you leave proxies,
Yes.
question on you. Owners who want to come in our office and see the proxies before the meeting, and they say, I want to know who already sent in their proxy. and in some instances, those proxies will show how people voted. Are they
In that
entitled to see
instance,
those?
I typically say no.
Okay.
Okay. I don't think it's an official record yet until the meeting's been held.
Okay.
Other lawyers could disagree with me. Okay. But
No, that's the stance we take. We don't
that's the
we
stance I
don't show
take.
those to owners before
Yeah.
the meeting.
And basically, I take that stance because I don't think it's an official record yet until that meeting's been held. But I don't have a problem with the association, the board, or the manager looking at those proxies to figure out how many people are coming. I know that
Correct.
sounds disingenuous, but that's how I feel.
That's how we've done it. If it's a board member, because between us and the board, we're responsible to keep the records. If the board asks me, we do look at those again for to try to see who we get quorum for. Because
Exactly.
sometimes they
Usually
have to go out and call
that's just
people or knock on doors.
that's for quorum purposes, and also how close are we, to the amount of people we need, let's say, to pass something.
Okay.
But don't count the votes. Okay.
I just want to know, and I just wanted to clarify that because we have had owners ask us that, and we've told
Okay.
them no.
But other lawyers could disagree with me, and that's okay. General versus limited proxy. I'm going to make a little segue here into condos, even though this is an HOA course. But for homeowner associations, unless your documents, okay, provide otherwise, you can use a general proxy. What is a general proxy? A general proxy is if I give my proxy holder the power to vote any way he or she wants on any issue being voted on at that meeting. So I'm going to use Marita as an example. If I give her a general proxy, that means she can use her own judgment. I'm trusting her to vote, for me as she ultimately decides, okay, because I'm not there. A limited proxy, though, a limited proxy is where on the face of the proxy, it limits how that proxy holder can vote. So on a limited proxy, it would basically have instructions. I hereby instruct my proxy holder to vote as follows on the following issues. And let's say vote on amendment to Article 12 of the Declaration, yes or no. I will mark it, okay, yes or no. If there's another issue, vote on something else, I will mark it before I give her the proxy, okay? Therefore, no offense here, Marita, when she goes to that meeting, she's a warm body. She's not exercising her judgment. She's basically there, but the proxy in itself, I call it like the first cousin of an absentee ballot. Okay. It's not an absentee ballot, a limited proxy, but it has the same effect because in essence, it's treated like a ballot because on the face of the proxy indicates how the owner is voting. The reason I was mentioning condos for a second, in condominium associations, owners can only vote by limited proxy on substantive matters. They cannot use general proxies. In HOAs, you can use general or limited unless your governing documents provide that, let's say, for example, that you can't use general proxies. You can only use limited proxies. And I've seen HOA documents that have that provision. So long story short, without spending too much time here, proxy voting, general versus limited, look at your documents or check your documents to see if there's any limitation on proxy voting as far as, can you only vote by limited or does it allow both? Okay. Both, though, can be used for quorum purposes. Electronic voting, all right? Electronic, or in other words, online voting, okay? Voting through the internet online. In order for the board to establish that, to have an electronic online voting system, it has to be done at a board meeting. The board meeting must be noticed at least 14 days in advance by mail delivery or electronic transmission, and the notice of that board meeting must also be posted in the community at least 14 days in advance, conspicuously, and similar to what I said before about membership meetings, the person providing that notice, posting that notice on behalf of the association, must execute an affidavit indicating that the 14-day notice requirements were met. By the way, those affidavits must be kept as part of the official records of the association. Now, this board resolution must provide that the owners will receive notice of the opportunity to opt in or opt out of online voting, establish reasonable procedures and deadlines for members to consent electronically or in writing to online voting, and procedures and deadlines to opt in or opt out of the online voting opt out after giving their consent to vote online. By the way, can't force people to vote online. This is just something that associations pass. And by the way, in my experience, usually when I do these live, I'll say, how many people have online voting? Raise your hands. Okay. Do you love it? Do you hate it? And in my experience, and I'm sure Marita can maybe attest to this, the associations that I work with that have it love it. They love it.
Hmm.
It's so simple.
It's where everybody wants to go now.
The counting is instantaneous in terms of counting the votes. So I'm not here shilling for that. I have no financial interest in any online electronic voting company. But just my experience. Okay.
Peter, I have to tell you, our associations that have gone electronic, it's their annual meetings are so much shorter because you don't have
Yeah.
people doing the labor, sitting at a table, counting all those ballots. And the people who can attend the meeting love it because they can vote from wherever they want to electronically.
Yeah. And a large association, I've been, and you probably have the same exact experience. I've been to large associations, no electronic voting, all paper voting, hours.
Yes.
People sit there and they
Hmm.
complain and they, to sound like my grandfather and my grandmother, they kvetch. How about that? And they get all
Right.
crazy and they get all crazy. And I say, look, this is the system, people. Now, again, I'm not selling electronic voting. Do what you want. I'm just saying, though, from my experience, it seems to be once you get it, you like it. All right.
Our associations love it. They're
Yeah.
all trying to convert.
So you can conduct your membership meetings voting through the online voting system if a member consents electronically or in writing to online voting, which is valid until that owner opts out, if ever, of the online voting. Also, when you vote online, you're also counted towards a quorum for that meeting. So it serves a dual purpose. You're there for quorum purposes, and obviously your vote is being counted the way you voted it. Now, if you have online voting, then each owner has to, and this is basically the stuff that the online system must do, okay? It has to have a method to authenticate the owner's identity, a method that's consistent with your documents and your election procedure and that's set forth in your bylaws, has to have a method to confirm at least 14 days before the voting deadline that the owner's electronic device, okay, i.e. their computer, can successfully communicate with the online system. The association must use an online system that is able to do the following things: authenticate the owner's identity, authenticate the validity of each electronic vote to ensure that the vote wasn't altered or tampered with in transit, transmit a receipt to every owner who casts a vote online, permanently separate any authentication or identifying information from that electronic election ballot, again, election ballot, rendering it impossible to tie an election ballot to an owner if your bylaws provide for secret balloting for elections. Some do, some don't. And store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. Now, before you go into a panic and saying, how are we going to do all this? How are we going to do this? This is impossible. Well, you know what? The companies that sell these software for these systems, they do this. Okay. So their
They do it all.
software basically, if it's proper, complies with all these requirements. It's not like you as the board have to be computer. If I had to do this, we'd be using stone tablets. That's how tech savvy I am. So, but the company that's selling you the software, they make sure their software complies with these requirements. Okay. What about the election process and the election procedure? And I'm going to skew a little bit at the condo again, just for comparison's sake, not for education really sake. So, a vacancy on the board, election directors, that is caused by the expiration of a director's term as opposed to some other reason must be filled by an election. So 1-year terms, end of the term, we have an election, right? To fill those vacant seats. The election, as I mentioned before, must be held in conjunction with your annual meeting or as provided in the association's governing documents. By the way, I've been doing this a long time. Like I said before, I've never seen documents that have the election at any other time other than the annual meeting. I guess it might be out there, but I haven't seen it. Okay. Now, the third bullet point is crucial, crucial, crucial. If you are doing this live, I would tell you to circle this and star it and put little people by it or whatever you do to make something, tab it. Elections must be conducted in accordance with the procedures set forth in the governing documents. This is completely different than condominium land. In condominium land, elections are conducted pursuant to statute, which is Chapter 718. We do not have a statutory election process procedure in Chapter 720. We do a little bit if you have secret balloting. I'll talk about that in a few minutes. But unlike condos where the statute supersedes the bylaws, if the bylaws are different, in HOAs, it's the bylaws that control. It's the bylaws that control. So you really have to conduct your election. I know I've hammered this for more problem than I should have, but it's just very, very important because I do see a lot of associations, for whatever reason, use a condominium style election when their documents have nothing like it in their documents. And quite frankly, it's wrong. But I don't know why. Maybe some managers do it that way. But again, do it pursuant to your bylaws. Okay, Peter, go on. Unless otherwise provided in your governing documents, a quorum of the members must be established in order to conduct an election and any other business at the annual meeting. Again, this is different in condominiums where there is no quorum requirement for an election. It's just 20% of the people voting. That's not an HOA provision, okay? There's one exception to HOAs having to have a quorum, and we'll talk about that in the next slide or two. But basically, you need a quorum. Remember, we talked about quorum before in order to conduct your election, a quorum of the membership. And unless otherwise provided in your documents, directors are elected by a plurality of the votes cast. So you don't need a majority of all the owners voting for you. You need who's getting the most votes. In other words, a plurality. The most votes cast. Who's eligible to serve on a board? Okay. All the members of the association are eligible unless they've otherwise been disqualified. So what makes an owner or a member potentially disqualified? A person who is delinquent in the payment of any monetary obligation, that's any monetary obligation, that can be an assessment, a fine, whatever, to the association on the day that he or she could last nominate himself or herself or be nominated for the board, cannot seek election to the board, and his or her name cannot be listed on the ballot. But that's crucial. When is the time period you can last nominate yourself? That goes back again to your bylaws. If you're going to have nominations from the floor, as many homeowner associations do, okay, and that means the last day you can nominate yourself is the day of the meeting or the day evening of the meeting. If your documents have a pre-nomination process, in other words, the bylaws have a process that's similar to condos, and let's say you have to have yourself nominated in advance, then that's the last day, okay? And that's the day that you must not be delinquent. So if you're delinquent on that last day, and then you become current the day after, too late, because that's the deadline. The deadline is the last day you can nominate yourself or be nominated, again, pursuant to your documents. All right, next disqualification. If you've been convicted of a felony in the U.S. or in a U.S. district or territorial court, or convicted of offense in any other jurisdiction which would be considered a felony if committed in Florida, then you're not eligible to serve on the board unless your civil rights have been restored for at least 5 years as of the date of election to the board. All right? So don't be a felon. A person who
Wait, I have a question for you. If they were convicted in New York, can they still run in Florida?
No. If what they did in New York is considered to be a felony in Florida, no. But if what they did in New York is considered to be a misdemeanor in Florida, yes. So it depends. So it depends. A person who has a pending criminal trial, this is pending. So these things, you don't have to be convicted. If you've just been formally charged or indicted or arrested, okay? So if you have pending criminal charges for forgery of a ballot envelope or a voting certificate used in an election, or if you've been charged with felony theft or embezzlement involving association funds or property, or tampering with physical evidence, such as the destruction of, the refusal to allow timely inspection or copying of an official record in furtherance of a crime, or obstruction of justice, you cannot be elected. You're not eligible to run for the board. Again, these are just, by the way, when I say formal charges, I don't mean someone standing up at a meeting and saying, Billy's a forger, Billy's an embezzler. That's not a formal charge. A formal charge is you've actually been indicted or arrested in a formal law enforcement type procedure. Nominations, very important. A member can nominate himself or herself or as a candidate for the board at a meeting where the election is to be held. So in other words, nominations, must be taken from the floor, except, right, bullet point number 2, there's an exception. If your election process in your bylaws, again, not just made up, not by rule, your rules can't conflict with your bylaws, so you can't create rules that are in conflict with that. But if your election procedure set forth in your governing documents allows candidates to be nominated in advance of the meeting, in other words, has a pre-nomination process, then the association is not required to take nominations from the floor at the meeting. Very crucial. So again, I'm probably going to repeat myself too many times today, but look at your documents. If in doubt, check with the attorney. The election day, ta-da. Election by acclamation. What does that mean? Well, an election is not required unless more candidates are nominated than vacancies exist. So let's say you have a 5-person board and you have 1-year terms, so all the seats are up. If you have 5 or fewer nominated candidates, then you don't need an election because you don't have more nominations or more nominees than there are vacancies to be filled. If an election is not required because there are either an equal number or fewer qualified candidates and vacancies exist, and if nominations from the floor are not required, then those candidates are automatically elected and you don't need a quorum. So remember before I said there's an exception to the quorum requirement? This is the exception, okay? This is the exception to not having a quorum for your election. It's if you have a pre-nomination process, therefore you don't have to have nominations from the floor, and you have the same or fewer number of candidates as there are vacancies to be filled. If those facts all exist for the meeting, then you don't need a quorum. So that's the exception for the quorum requirement for HOAs.
Peter, at the meeting, do you have to motion and second to accept the election by acclamation?
Technically, no. You can do it. I don't think you technically have to, because as long as it's clear on the minutes that you had 5 candidates and there's 5 seats, then the owners can't deny that. Okay. It's not wrong. Okay. But basically it's by operation of law. So by operation of law, if you have the same or fewer number of candidates as there are vacancies, they're automatically on the board. Members have the right to vote in person or by proxy, as we mentioned before, unless otherwise provided in your documents. So I'm going to hammer this for the 100th time. Check your documents to see what the voting limitations, if any, are. Voting by proxy, voting, ballot voting, whatever. If your governing documents, so it's if your governing documents permit voting by secret absentee ballot, and by the way, I've seen many associations, they just mail out ballots. They just mail them out, even though their documents have no provision for basically mailing out the ballots before the meeting. And if they don't say that, then you don't do it. Okay. Even though you might think it's more efficient. Or my favorite thing is, but Peter, we've always done it this way. Always done it this way is not a really good legal argument. Okay. Yeah. It might be good talking to your kids, maybe, but we've always done it this way is not legally sufficient. So if your governing documents permits voting by secret absentee ballot, then in that instance, the ballot must be placed in an inner envelope with no identifying markings other than maybe just says ballot, and mailed or delivered to the association in an outer envelope, which identifies the name of the owner, member, the lot for which that ballot is cast, and the signature of the member casting the ballot. That is similar, by the way, to those who have been to condominium elections. But in condos, that's required. It's a requirement of how you cast your ballots. For HOAs, it's only required if your documents, if your bylaws provide for absentee secret balloting for elections. All the ballots and proxies are tabulated on the day of the annual meeting. If more than one ballot is submitted for any lot, the ballots for that lot are disqualified, and any vote by ballot received after the closing of the balloting may not be considered. So here, Marita, I would take a motion at one point to close the balloting. Okay. In other words, after nominations and after people have, the ballots have been passed out, and then turned in, we didn't have a motion that balloting is closed and have that approved. Unless your documents have a provision about when the balloting is closed, and obviously then you follow that. Okay. Again.
Yeah, it's very rare. I don't think I've seen that, but we have had it where somebody comes running in the room with a ballot and we just close them, and then they motion and second to open and motion and second to close again so they can accept that ballot.
Okay. Because in condo land, it does it by operation of law. So in condominium land, when they start opening the outer envelopes, balloting is closed.
Right.
And I had one guy several years ago run in, just got off a plane from Canada or something, had his ballot, and I didn't accept it because they had started to open the outer envelopes. So, that was just one instance. All right, unless your bylaws provide otherwise, directors serve 1-year terms. Now, if your bylaws say they serve staggered, let's say, 2-year terms or staggered 3-year terms, then obviously that would control. Election challenges. Okay, and very, very important. Any challenge to the election process must be commenced within 60 days after the election results are announced. So even though I've been hammering on the process and the procedure and follow your bylaws and make sure you do everything right, I guess as a matter of course, if you do everything wrong and no one challenges it within 60 days, then you've done everything right. It's too late to challenge it. I'm being a little facetious here. I'm not encouraging you to do that, okay? On the hope that no one challenges you. But generally speaking, it's a pretty short window to challenge an election. That makes sense, right? Because, being in the office is a fairly short time, 1 year, and you don't want people challenging an election 8 months into it. That would be kind of crazy. All right. So where do you do the election challenges? Well, the venue for an election dispute between an owner and the association, that dispute or that challenge must be submitted to binding arbitration with the Division of Florida Condominiums, Timeshares, and Mobile Homes. They do have jurisdiction over HOA elections, okay? Or filed with a court of competent jurisdiction, which would typically be the circuit court of the county where your association is located. Election disputes submitted to binding arbitration with the division must be conducted in a manner provided by 718.1255, that's in the Condo Act, and the procedural rules adopted by the division. So that's one of the few areas where the division, which actually controls or has jurisdiction over condominium associations, does have jurisdiction with respect to HOAs because it has jurisdiction over HOA election disputes. Election of officers. So we've gotten your board in, right? Yay, board members are in. Now we elect officers, right? Generally, under almost every set of bylaws I've seen, not everyone, but almost everyone, the officers are appointed or elected by the board immediately following the election at the organizational meeting of the board. Now, oftentimes your bylaws will be very specific about when that meeting must be held. Typically, I see it must be held within X days of the election. In my experience, oftentimes it happens right after the election, where it's the same night, not always. But if you're going to do that, in my opinion, probably opinion of everyone else who does what I do, you should be posting notice then along with your notice of your annual meeting, also post notice that the organizational meeting of the board is going to be held immediately following that. It's a separate meeting and it's entitled to a separate posting of notice. You could combine it, but make sure it is noticed. Okay. How can directors vote? Okay. Directors, we talked about all that proxy voting before. Well, when you're in a role of a director and you're voting as a director, as opposed to voting as a lot owner for a membership meeting, directors cannot vote by proxy or vote by secret ballot at board meetings, except the only exception is that secret balloting may be used in the election of officers. So you can elect your officers by secret balloting. Otherwise, no, all board votes are done in the open where everyone can hear how every director votes. And there is no proxy voting. There is no giving someone a slip of paper, oh, Billy voted like this, and I have Billy's piece of paper and Billy signed it. That's not good. Okay. You gotta be there at that board meeting. Now, there is no prohibition against changing officers midterm, and you'll see most bylaws, almost all, most do say that although officers are elected to, let's say, 1-year terms, they also serve at the pleasure, I think a better word is displeasure, but they serve at the pleasure of the board. So the board, again, unless the bylaws provide otherwise, can change officers midterm. You can't take directors off the board, okay? But you can change officers. So if you don't like the job the president, vice president, treasurer, whoever is doing, you can change up officers. It's an open board meeting. Could be a secret ballot because it is secret balloting is possible, but officers don't have any entitlement necessarily to serve out that. I'm not saying you should do this. Okay, I'm just telling you there's a difference between directors and officers in terms of how they're changed. Directors cannot recall or remove other directors though. Once a director is on the board, unless they are disqualified because of resignation or death, or they no longer are an owner, if they must be an owner, the only way to get directors off is through recall by recall vote of the other owners or by the owners. Fraudulent election voting activities. And I'm sure this will not apply to anyone who is listening to this, but we're going to mention it. A person who engaged in the following acts of fraudulent election voting activity commits a first-degree misdemeanor. Okay, what are they? Willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear to or affirm an oath or affirmation in connection with or arising out of voting activities. Perpetrating or attempting to perpetrate or aiding in the perpetration of fraud in connection with a vote cast or to be cast or attempted to be cast. Preventing a member or an owner from voting or preventing a member from voting as he or she intended by fraudulently changing or attempting to change a ballot envelope, vote, or voting certificate of the member. Menacing, threatening, or using bribery or any other corruption to attempt directly or indirectly to influence, deceive, or deter a member when the member is voting. I know this all seems like common sense. These are all pretty obviously terrible things, but again, these are all been added to the statute to codify them as fraudulent voting actions. And there's more. Giving or promising directly or indirectly anything of value to another member with the intent to buy their vote. Well, you must really want to be on the board bad if you're buying people's votes. But these are fraudulent voting activities. So you can't be giving people something of value, whether it's money or anything else. However, this does not apply to any food which is consumed or served, which is served to be consumed at an election rally or meeting, or to any item of nominal value which is used as an election advertisement. So if someone's running for the board is going to have a vote for Billy barbecue, okay. Or going to wear a vote for Billy pin, okay. But other than that, can't be buying people's votes. Finally, using or threatening to use or directly or indirectly force, violence, or intimidation, or any tactic of coercion or intimidation to induce or compel a member to vote or refrain from voting on a particular ballot measure. So even election or any other issue. Okay. Each of these activities or acts constitutes also a first-degree misdemeanor. This was added to the law in July 1 of 2024. Knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, or having knowledge of a fraudulent voting activity and giving aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. Now, we talked about vacancies occurring because of the expiration of a term. So what about other vacancies, that occur before the expiration of a term through death, resignation, or disqualification? Well, unless otherwise provided by your bylaws, any vacancy occurring before the expiration of a term, not including recall, may be filled by the affirmative vote of a majority of the remaining directors, even if the remaining directors are less than a quorum, or even if there's only one remaining director. Okay, so if someone dies, someone resigns, someone is disqualified because they're a felon, someone is disqualified because they're more than 90 days delinquent in a payment. We'll talk about that in a second. If they're off the board for these disqualification reasons or resignation, death reasons, the remaining board members fill that vacancy again, unless your bylaws provide otherwise. Alternatively, a board can hold an election to fill the vacancy, in which case that election must comply with the governing documents. In my experience, typically this does not occur. Typically, the board will appoint the replacement, but it can. Unless otherwise provided in the bylaws, a board member appointed or elected to fill a vacancy before the end of a term serves the unexpired term of the seat being filled. All right. So unless your bylaws provide otherwise, the person that's appointed to fill that vacancy serves the unexpired term. Now, I have seen documents, and you have to look, where if directors say they're serving 2-year staggered terms or 3-year staggered terms, Sometimes the bylaws will say if a director dies or resigns or whatever, his appointment only serves to the next annual meeting. And I've seen it. So you do have to check your bylaws. It's somewhat rare, but it's certainly not so rare that you shouldn't check. So if you do have multiple year terms, you need to check to see if there's anything in there regarding the term of a director who was appointed to fill a vacancy, caused by other than expiration of term. Okay, done with the membership meetings for the time being, off into board meetings. A meeting of the board, or is it? This is actually, it seems like a simple question. I wish it had a simple answer. I really wish to God, well, not God, he has better things to do, but I really wish that this would be addressed, because what is a board meeting? Well, a board meeting is defined as a gathering of a quorum or more of the board to conduct association business. What is conducting association business? It's never really been defined. Okay. You can say it's like obscenity, which is, I know it when I see it, as the Supreme Court said many years ago. I take a pretty conservative view on it. I know some lawyers, even lawyers in this firm, take a more aggressive view of what is conducting association business. To me, conducting association business is really any time the board gets together and is substantively discussing association business, even if they're not voting. Okay. I know some lawyers take the position, well, as long as there's no votes taken, it's not a board meeting. I don't go down that road, because then when you go to the board meeting and you vote on something without discussion, people say, when the hell did you guys vote on this? Or when did you guys discuss this? You just knew it by, osmosis. So again, I'm pretty conservative. Now, it doesn't mean on that issue, it doesn't mean that if you're all together having dinner and you're talking about the weather, you're talking about sports, you're talking about politics, hopefully not, or you're talking about whatever you're talking about, that's not a board meeting. But I would say you have to strive, if there's a quorum or more, again, quorum or more. If it's less than a quorum, doesn't, kind of like there are no rules. But if it's a quorum or more of the board, then in my opinion, strive not to be discussing in substantive terms association business. Maybe to agree on what the agenda is for the next meeting, fine. That's just your board agenda. Or other things like that. I tend to, again, not to belabor this, I'm a little conservative on it. Some may be more aggressive than I am. The officers and directors of the association have a fiduciary responsibility to the association, or excuse me, to the owners and the association. Fiduciary, that term gets thrown around a lot. Really, what does it mean? It really means trust. You're in a position of trust to your owners. Does that mean you always have to be right? No. Okay. There's something called the reasonable business judgment rule. And what is that? That means that a board member, okay, needs to act in good faith with the best interests of the association in mind. All right. Generally speaking, the powers of the association are exercised by the board. There's very few things typically that owners really have a right to vote on, other than amendments, sometimes alterations to the common area, depending on what your documents say. But for the most part, the association is run, by and large by the board, with owners only having a right to vote on things where the documents or the law expressly provides. On that third bullet point, unless delegated, no one board member should be making decisions for the board. And, I can't tell you how often in my career, one person seems to be calling all the shots. Usually president, not always. Okay. But, you can't just defer your decision-making authority to the president, okay, or allow the president just to rule the place. You're on the board. Act like a board member. Okay. You have fiduciary responsibility to use your judgment and exercise your judgment in good faith. Again, don't always have to be right. Don't always have to be right, but you have to be acting in good faith and acting reasonably. Now, as I mentioned before, can't vote by proxy or secret ballot unless you're voting for officers, then you can use secret balloting. And by statute, members of the board can use email as a means of communicating with each other, but you cannot vote by email. What about board
So
meetings?
can I just ask a question on that? Because we have, and we've been told if there is a contract that they need to take care of in between a meeting, and we send it out to all of the board members for a vote, that as long as those board members all vote yes, we can put it on the next agenda and ratify it.
You can ratify,
Okay.
okay? You don't even necessarily have to have all vote yes. But ratification, and by the way, what does she mean by ratification? Ratification is a valid way for the board, in essence, after the fact, okay, after they've done something, to ratify that as a board meeting. But I would stress, in my opinion, again, this is just my opinion, other lawyers can disagree.
Try
In
not to do
my
it.
opinion, it should be used sparingly, okay? Only when necessary, all right? To get the business of the association done. It should not be a modus operandi. It should not be a crutch, because you have to strive to make your decisions at board meetings. But every now and then, if necessary, you can take an action and then ratify it at the next board meeting. All right. All board meeting notices must include a date, time, and place of the meeting and must specify all agenda items for that meeting. If you're going to be considering an assessment, okay, typically a special assessment or even a budget, okay, notice of the meeting must include a statement that assessments will be considered and the nature of the assessments. And we'll talk about special assessments at the very bottom there. Unless the bylaws provide otherwise, okay, or by law, and I should say that there, it doesn't. So unless the bylaws provide otherwise or by statute, notice of board meetings must be conspicuously posted in the community at least 48 hours before the meeting, except in an emergency. Oh, by the way, that's a bona fide emergency. That's not a made-up emergency, okay? And the fact that, this is now May, and 3 board members are going home to New York, New Jersey, wherever next week or tomorrow, I don't consider that to be an emergency. All right. So bona fide emergency, yes. Other than that, post a notice. But there are certain meetings that you need more than a 48-hour notice. Okay. For example, unless otherwise provided by your bylaws, written notice of any meeting at which a special assessment or an amendment to a rule regarding the use of a lot is going to be considered. That notice of that meeting must be mailed, delivered, or electronically transmitted to all the owners and conspicuously posted on the property at least 14 days before the meeting. And this is especially crucial when it comes to special assessments. Well, rules too, but because if you don't adopt the special assessment properly, then it won't be collectible. Okay. So if you haven't crossed T's and dotted I's in terms of the meeting notice, all right, as far as sending that board meeting notice out to all the owners and posting it 14 days in advance, you can't do one or the other, you got to do both. Then someone who doesn't pay that assessment can defend not paying it, okay, on the grounds that it was not properly adopted. In addition to other notice requirements or other notice methods, the association may adopt by rule a procedure for conspicuously posting the board meeting notice and agenda on the association's website or app for at least the minimum period of time for which notice is also required to be physically posted on the property, which again, either 48 hours or 14 days. Any rule adopted must include a requirement that the association send electronic notice to the members whose email addresses are included in the association's official records in the same manner as is required for notice of a meeting of the members. That notice must include a hyperlink to the website or app on which the meeting notice is posted. And we're going to get the meeting notices on websites and apps in a second anyway, because it dovetails with this requirement about websites. By January 1 of last year of 2025, an association of 100 or more lots is required to have a website or application and must post notice of any board meeting, the agenda, and any other document required for such a meeting no later than the date required for the notice. So similar to membership meetings, on your app or website, you also have to post the notices and other documents associated with a board meeting. Similar to membership meetings, all meetings of the board must be open to all the members, but there are 2 exceptions to when a board meeting does not have to be open to the members. The first is when the board is meeting with the attorney for the association with respect to proposed or pending litigation where the contents of the discussion would otherwise be governed by the attorney-client privilege. Okay, I realize that is regard to litigation. Okay, So pending or proposed litigation, and or whatever, meetings held for the purpose of discussing personnel matters. So if you're discussing the hiring, firing, compensation, discipline, whatever of association employees or even management company employees, then that is those two meetings are privileged or closed. I shouldn't say privileged, they're closed. By the way, interestingly enough, they're not exempted from the meeting notice requirement, but they are exempted from owners attending those meetings, having a right to attend. So something to be aware of. Members have a right to attend all board meetings other than the ones we just mentioned, and have the right to speak at any board meeting with reference to all designated and agenda items. The board, or excuse me, the association through the board may adopt reasonable rules regarding the frequency, duration, and other manner of member statements, including, for example, requiring them to sign up in advance, okay, for those wishing to speak and indicating which items or which agenda items they wish to speak on. Again, particularly if you're having meetings that are a little out of control, but if you don't, having these rules in place, I think is a good thing. Make them reasonable. It will give structure to your board meetings and keep them moving smoothly. Unlike a member's right to speak at ownership or member meetings, there is no statutory prescribed time limit, time restriction for the members to speak at board meetings, although a minimum of 3 minutes is probably a good rule to adopt with respect to speaking at a board meeting. Recording, similar to the membership meeting, an owner can audio or video record board meetings. And again, you can adopt reasonable rules regarding the recording and taping. Handicap access, similar to what I said before about membership meetings, board meetings must be held at a location accessible to physically handicapped persons if requested by a physically handicapped person who has the right to attend the meeting. How about paying the board members, right? You all got this job because big money. Here comes the big money, come the big bag, as they say. Well, probably not. A director, officer, or committee member may not directly receive any salary or compensation from the association for the performance of duties as a director, officer, or committee member, and may not in any other way benefit financially from service to the association except for the following. Here's the following. You can't participate in a financial benefit accruing to all or a significant number of members as a result of actions lawfully taken by the association. You can be reimbursed for out-of-pocket expenses incurred on behalf of the association, subject to applicable approval procedures. I would adopt those procedures in terms of making sure that there's receipts and paperwork and approval for whatever the expense may be. Recovery of insurance proceeds derived from a policy of insurance maintained by the association for the benefit of the membership. Any fee or compensation authorized in the governing documents or by a vote of majority of voting interest, voting in person or by proxy at a meeting of the membership, and a developer or its representative serving as a director, officer, or committee member of the association, because obviously they're being paid for their position as a, as such. All right, grounds for immediate removal. And some of these are repeats for what we said before. A director or officer who is charged by information or indictment with any of the following crimes must be removed. Again, this is just charged. Forgery of a ballot envelope or a voting certificate used in an election. Theft or embezzlement involving association funds or property. Tampering with physical evidence as provided in the Florida statute. Destruction of or the refusal to timely allow inspection or copying of an official record in furtherance of a crime, not just not allowing it just for the hell of it, but in furtherance of a crime. Obstruction of justice as provided in Chapter 843, and any criminal violation under Chapter 720, Florida statutes. Now, in the event that occurs, someone is off the board for one of those reasons, then the board must fill that vacancy until the end of the period of the suspension or the end of the director's term of office, whichever occurs first. If the charges are resolved without a finding of guilt and without acceptance of a plea of guilty or nolo contendere, which is no contest, the director or officer must be reinstated for any remainder term of his or her office. So if somebody is charged with one of those crimes and then the charges are dismissed, okay, then that person is then reinstated, right? While the criminal charges are pending, the person may not be appointed or elected to a position as an officer director of any association and may not have access to the official records of any association except pursuant to a court order. Now, this is removal, which is not necessarily temporary. If a director becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation, that would include obviously an assessment, to the association, that person is deemed to have abandoned his or her seat on the board, creating a vacancy on the board to be filled. So if I'm on the board and I become more than 90 days delinquent, I'm off. Okay. Even if I pay and now I'm current, 2 days later, too late, because I abandoned my office, okay, by becoming 90 days delinquent in the payment of that obligation, fee, fine, assessment, whatever, to the association. What about conflicts of interests? Okay. This area doesn't arise too often, but it does arise. So what is a conflict of interest? Directors and officers, okay, must disclose to the association any activity that may be reasonably construed to be a conflict at least 14 days before voting on an issue or entering into a contract that is the subject of the conflict. Okay, so like I said before, what is a conflict? Well, there's a rebuttable presumption that a conflict occurs or exists if any of the following acts occur without prior disclosure to the association. A director officer or a relative director officer enters into a contract for goods or services. So, if I'm, selling services to the association or selling goods to the association, I'm on the board, that's a conflict. A director officer or a relative director officer holds an interest in a corporation, LLC, partnership, a limited liability partnership, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. So if I am, if I have a financial interest, ownership interest in a company, let's say it's a pest control company, and they hire my company, the association, well, that has to be disclosed. Okay. Or even if a relative of mine, okay, has a financial interest in that company, that has to be disclosed as a conflict of interest. If the association enters into a contract or other transaction with one of its directors or a corporation or other entity in which a director is also a director or officer or is financially interested, not including, okay, or excluding an affiliated HOA, then the board must comply with the following requirements. The proposed contract with the director must be fully disclosed to the board, and the disclosure entered into the minutes of the board meeting at which the proposed contract is to be considered and voted upon, and that contract must be approved by at least 2/3 of the directors that are present, 2/3 of the uninterested directors. The contract or transaction must be reasonable and fair to the association. And then at the next regular special membership or ownership meeting, the existence of that contract or transaction must be disclosed to the membership. Then at that membership meeting, after it's been disclosed, upon a member's motion, the contract may be canceled by a majority vote of the members present at that meeting in person or proxy. If the members cancel the contract, at that meeting, then the association is only liable for the reasonable value of the goods or services provided up to that time and is not liable for any termination fee or liquidated damages or other cancellation or termination penalty. Document posting. And we mentioned this before, we're going to mention it again. Notice of any board meeting and the agenda and any other document required for the meeting, they must be posted no later than the date required for the notice. Okay, posted on your website. Notice of any membership meeting and the agenda for the meeting must be posted at least 14 days before the membership meeting, posted in plain view on the homepage of the website or on a separate subpage of the website labeled notices, which is conspicuously visible and linked to the homepage. The association must also post any document to be considered and voted on by the membership at that meeting, or any document listed on the agenda for that meeting at least 7 days before the meeting, at which document or that information within a document is going to be considered by the membership. This is a repeat from another slide. I realize that, but we're just emphasizing the point. What about minutes of meetings? Okay. And although this is not statutory, this is still something that's interesting and I should be you should pay attention to. All meetings must have minutes taken. That's meetings of the membership as meeting of the board. The minutes do not need to be verbatim. and in my opinion, they should not be verbatim. And I'll explain why. Minutes must be maintained in written form or in another form that can be converted to a written form within a reasonable period of time. And then that last bullet point, a vote or abstention from voting on each matter voted upon for each director present at a board meeting must be recorded in the minutes. So you can't just say that the matter was approved by a vote of 4-3, or it was defeated by a vote of 4-3. You have to indicate how every director voted yes, no, or abstention. And then second bullet point, minutes do not need to be verbatim. This is not the congressional record, okay? The minutes should reflect who was at the meeting, did you have a quorum, what motions were made and what was the motion, who seconded the motion. But I would not include all the discussion in terms of Bill said this, Johnny said this, Susan said this, et cetera, et cetera. That's not necessary, quite frankly. That could come back to haunt you in future instances. I remember years ago when we had all the hurricanes 20 years ago or more, and condo associations were trying to file their insurance claims, and the insurance companies sent down their teams of investigators, and they had a right to review the records because that's what the policy said. And they saw in the minutes of meetings all sorts of discussions in there about windows being bad or this being bad or that being bad, even though the association was now trying to claim damages for those things. So the minutes actually, even though I'm not saying they should have committed fraud or anything like that, but the minutes were too detailed. So if owners want to record meeting, they can. So if an owner wants to record every word spoken, they can, as we mentioned before. In my view, the official minutes, though, are just that. They should just reflect the business that was taken, who was there, quorum achieved or not achieved, motions made, vote on the motion. And no owner, by the way, has a right to demand that something be set forth in the minutes, even though they like to stand up and make those speeches sometimes. Okay.
Okay, that's important, not to interrupt you, but there are times where a board member will say they want it in the minutes, or an owner will say they want it in the minutes. So I want to be clear, especially for our boards that are on here. We do not have to put that in the meeting minutes, correct?
No, no individual person, even a board member, has a right to demand that a letter that they wrote or a statement that they made be in the minutes. Okay. The minutes are just what they are. They're reflecting the business that was taken. Now, if they want to send their letter to the board or send their statement to the board, fine. Use your email, use your stamp. But no, they have no right to demand or require that the minutes reflect that statement.
Thanks. I just wanted you to clarify that
Yep.
because sometimes people don't believe me. So that's why I wanted them to hear from
They don't
you.
believe you. Sometimes they don't believe me either. So we're even. Notice and adoption of the budget. By the way, this is completely different from condominium associations. Just want to make that point first, because some people are used to their friends who are on condo boards and say, well, this is the way we do it. You must do it this way. And again, the law is different in this respect for budgets. The governing documents of your association must be reviewed for any specific budget meeting notice and adoption requirements, because Chapter 720 or the Homeowner Association Act does not contain specific notice or agenda requirements for budget meetings. Completely different than condominium associations, where it's very specific. And in fact, in this recent amendments to the Condominium Act, it's become even more specific as to what condominium associations must do. But there is no specific budget adoption process in the HOA Act, but you do have to look at your documents for what they say, because they may have specific requirements. If your documents are silent, okay, then notice of a board meeting at which the proposed budget will be considered and adopted must be posted conspicuously at least 48 hours before the meeting. If you want to do it more in advance, obviously you can. If you want to do it by mailing, you can, okay? But again, there's nothing in the statute that says you have to, but check your documents out. Before a budget adoption, unless your documents require the board to provide a copy of the proposed budget to the owners before the meeting at which will be adopted, the board is not required to do so by law. But please consider sending it to all members prior to board adoption anyway. Again, not to repeat myself, but there's nothing in the statute that requires the budget, unlike condos, where they have to send out the budget in advance of the board budget meeting. In HOAs, they don't, unless your bylaws or declaration or articles require it. but you may consider doing it anyway, just as a matter of good business practice. What about after it's adopted? Once the budget has been adopted by the board, again, you could have a set of bylaws that says, oh, you need owner approval. That's rare, but check. 99.9999% of the time, it's a board function. All right. Once the budget is adopted, then the association must provide every member with a copy of the budget or written notice that a copy is available upon request at no charge. If requested, then a copy of the budget must be provided to the member within a time frame set forth for inspection of association records, which right now is within 10 business days of receipt of a written request. And again, on the bottom there, I've already said this a couple times, by January 1st of last year, if you have 100 or more lots, you're required to post a copy of the budget on your website or your app.
And Peter, just to clarify that, because we have portals that are the same as our websites, if we post a copy of the budget, we do not have to mail it out to the members when we send out their coupons, correct?
I do not think you do. No.
Okay.
Okay. But if
Some of the boards don't want to, so I just want to clarify that, yes, that is correct. They don't have to.
But if an owner wants one,
Yeah. Well, they can see it. We send them to the portal and tell them how they can log in and they can see it and print it.
They can see it and print it, but if they can't do that, if they're incompetent,
Just send them a copy.
Send them a copy. Okay. In a condominium act, it says you can just refer them to the website. It doesn't say that in the HOA Act as far as record inspection. Special assessments, and we talked about this already a little bit, so we're going to talk about it some more. Written notice of any board meeting at which a special assessment will be considered must be mailed, delivered, or electronically transmitted. And remember, you can only electronically transmit notices to those owners who have agreed in writing to receive meeting notice in that manner. Okay. But it must be sent to the owners and conspicuously posted on the property at least 14 days before the meeting. The notice of the meeting must include a statement that special assessment will be considered and the nature of the assessment, and should identify the estimated cost of the assessment. Okay. I would say not should, shall. Okay. In my opinion. Once levied, the association should send written notice to the owners, and I would strongly encourage this, notice to the owners of the special assessment and allow the owners a reasonable period of time, which may be set forth in your documents, okay, within which to pay the assessment. If your documents, though, have any other additional requirements, follow those requirements, okay? So if your documents have requirements in addition to this, follow those as well. A special assessment that has not been paid by an owner can be collected in the same manner as regular assessments. In other words, through your lien and foreclosure process. What about committees? Okay. Unless the articles or your bylaws otherwise provide, the board is entitled to create two types of committees. There's a board committee and an advisory committee, although most committees fall into the second category. A board committee, if you have a board committee, then a majority of those on the committee must be directors, unless the committee is created by the board or is otherwise authorized by the articles, and the committee relates to the election, nomination, or qualification or credentials of directors, or is involved in the process of electing directors. An advisory committee is any number of persons on the committee can be non-directors or not be directors. An advisory committee cannot act on behalf or exercise any of the powers or authority of the board to bind the association to any action, but may make recommendations to the board, to the officers, or to the members. And most committees are advisory committees. However, fining and use right suspension committees, and we'll talk about that in a few minutes, architectural committees and organizing committees, and that's if you have to revitalize your documents because they've expired because of the Market Worker Title Act, they're not subject to those category requirements. The same meeting requirements apply to meetings of. So, which committees have to meet like the board meets, i.e. with the same type of notice and the same right of owners to attend? Well, there's two types. Unless your documents have additional committees subject to this, any committee, when a final decision will be made regarding the expenditure of association funds, that's kind of rare, but if you do have a committee that's authorized to do that, that committee meeting must be noticed and open to the owners. And interestingly, any committee having the power to approve or disapprove architectural decisions with respect to a lot. So this is one where a lot of associations, quite honestly, don't comply because they don't realize it. Your ACC, ARB, whatever you call your architectural committee, assuming you have one, okay, that committee those committee meetings, when they're making those decisions, that has to be noticed and open to the owners. And this is a way to get challenged, quite frankly, if you're trying to enforce an architectural committee decision and the meeting that they made that decision wasn't properly noticed or wasn't open. And I know this, I won't say this is little known, but it's been in the HOA Act for a while. So just realize that these two types of committee meetings, the second one probably more frequent than the first, they have to be subject to the same requirements as a board meeting in terms of notice and being open to attendance by your owners.
Can
How
I
about,
can I ask one more question just before you leave that? I'm sorry, Peter. And again, these are questions that I know my boards ask that we discuss
okay,
with them a lot. So when they're deciding on a violation and they have the homeowner come in, that it's one of the homeowners that wants to come and plead their case. When that homeowner is done, they leave and then they close the meeting and make their decision.
is this
Is
about an
that correct?
architectural decision or is this about any?
This is for a fine. It's for somebody on a fine. Somebody has a violation, garbage can violation, and they come in, they had some type of hardship, they want it waived. Before that committee makes that decision, they excuse the homeowner and then they make their decision.
Well, the fining committee meetings, those are not open to the membership. You don't have to notice
Okay.
those. If it's a
So
board,
even the person who's being fined, they leave while they make that decision, correct?
there's no, the law doesn't really address that, quite
Okay.
frankly. I think that's probably okay.
Okay.
If it's a fining committee, okay?
Right.
But if the board is meeting to determine whether to fine someone,
Right. That's open.
that's open, okay?
Okay.
I think your fining committee, you're all right.
Okay.
I haven't had that question before. Thanks for putting me
A
on the
lot
spot.
of these, well, they want to go and be able to talk to each other without, the person who came in, like we go representing the
Yeah, I don't
management
know of
side of
any
it.
requirement that in a fining committee that the fining committee has to have its deliberations in front of the
Okay.
accused, so to speak.
Okay.
Interesting question, though. Now, where was I? Okay. All right. All right.
Next one. Yep.
The association has the authority to fine, and again, now this is for non-monetary violations. So this is for violations of rules, restrictions, covenants, but not for failure to pay. So not dealing with not paying assessments or something. So a non-monetary issue. The association has the authority to fine and suspend use rights for failure to comply with the documents. However, you cannot impose a fine or a use right suspension unless the board first levies the fine or use right suspension at a properly noticed board meeting. And this number one point is one I think a lot of associations fall down on, where, and I have associations that still do this, where the board will delegate to the committee the authority to make that initial decision whether to fine someone. And that's not how it works. The board initially decides to levy a fine or suspension upon whoever, okay, at a properly noticed and open board meeting. Then, after the board levies that fine or suspension, then the board provides that party, that person, okay, at least a 14-day written notice of a hearing on the violation. The notice must provide a description of the alleged violation, the specific action required to cure it, if it can be cured. In other words, if it's an ongoing violation, if it was something that happened before and it's now gone, obviously there is no cure, and the date and location of the hearing and access information if the hearing is to be held by telephone or other remote means, Zoom or something like that. If the violation is cured before the hearing or in the manner specified in the hearing notice or notice of the committee's findings, then the fine cannot be imposed. If a violation is not cured and the fine levied by the board is approved by the committee by a majority vote, the committee must set a date by which the fine must be paid, and that date must be at least 30 days after delivery of the notice of the committee's findings. Attorney's fees and costs may not be awarded against the parcel owner based upon the actions taken by the board before the date set forth for the fine to be paid. If a violation of the fine levied by the board is approved by the committee and the violation is not cured, the fine is not paid, per the notice of the committee's findings, reasonable attorney's fees and costs may be awarded to the association. Attorney's fees and costs may not begin to accrue till after the date notice for payment and the time for an appeal has expired. A fine cannot exceed $100 per violation, as otherwise provided in the governing documents. For condominiums, by the way, fines can't exceed $100 per violation, period. Okay, big difference here. In HOAs, they can if your documents allow greater than $100 per violation. By the way, if your documents say you can only fine up to $50, then you're limited to that. Okay, so the $100 per violation, unless your documents provide otherwise, and may be levied on the basis of each day of a continuing violation, but may not exceed $1,000 per violation in the aggregate, again, unless otherwise provided by your documents. A fine of $1,000 or more may become a lien against the lot and collected through the lien foreclosure process or procedure if the authority to do so is in your declaration of covenants. Another distinction here, in condominiums, you're limited by the amount you can fine. It's by statute, no more than $100 per fine, no more than $1,000 in the aggregate for continuing. And in condominiums, there is no liens for fines. A huge difference. In an HOA, you can lien for a fine of $1,000 or more if your declaration gives that authority. What about suspending use rights? Suspension of the right to use the common area and facilities does not apply to that portion of the common area used to provide access or utility service to the lot and cannot prohibit an owner or a tenant of a lot from having vehicular and pedestrian ingress to and from the lot, ingress and egress, including but not limited to the right to park. That would be pretty harsh. A suspension applies to a member, and when appropriate, the member's tenants, guests, and invitees, even if the violation resulting in a suspension arose from less than all the multiple lots that are owned by that particular owner. Now, there's two things that you can't fine or suspend for. I thought this was kind of, I don't know, I found it not amusing, but interesting. Okay, they had these two carve-outs. You cannot fine an owner for leaving the garbage receptacles at the curb or the end of the driveway within 24 hours before or 24 hours after the designated garbage collection day or time. Also, you cannot levy a fine for leaving your holiday lights or decorations or other improvements out longer than indicated in the governing documents unless the decorations or the lights are left up for longer than 1 week after the association provides written notice of the violation to the owner. Obviously, someone knew someone in the legislature who didn't like the garbage can and the holiday decoration fines. Okay. Use right suspensions. And by the way, the reason I'm buzzing through this a little bit is I was looking for, and maybe I skipped past it quickly. Who can be on this committee, by the way? The fining or suspension committee. By the way, that committee is limited in its role. Okay, this committee can only approve or disapprove the fine or suspension levied by the board. It's like a little appellate body. It can't change it. It can't modify it. Its complete authority is to approve or disapprove the fine or suspension levied by the board. That's their complete and entire role in this process. All right. What about suspending use rights if you're delinquent, if you fail to pay your monetary obligations for more than 90 days? You can suspend an owner's right to use the common area facilities if an owner is more than 90 days delinquent in any monetary obligation. Again, that's assessment, other fine, fee, something. Now, this is done through board at a board meeting, and this doesn't go through the committee. Okay, unlike fines and suspensions for violating non-monetary provisions for being delinquent and your use suspension, then the board imposes that. For suspension to take effect, written notice of the suspension must be provided by mail, hand delivery, or email, which again requires owner consent, to the owner and, if applicable, to the occupant, licensee, or invitee of that owner's lot. A suspension of the right to use common areas is similar to what we talked about before. It does not apply to the common area used to get ingress and egress to the lot, utility services to the lot, and you could not prohibit an owner again from having access, vehicular or pedestrian, and you can't impose or suspend their right to park. Similar to the other things, suspension applies to a member and when appropriate, the member's tenants, guests, or invitees, even if they own multiple lots, it only applies to one of those lots. And the suspension ends when they're current, when they full payment of the delinquency. What about suspending voting rights? Okay. That can be done, except there is an exception. We'll talk about it in a second. An association may suspend an owner's voting rights if they're more than 90 days delinquent in any monetary obligation. Again, at a board meeting where it's duly posted. When you post that board meeting notice, I know people are afraid. I have no issue with putting the lot number, lot address. If you don't want to put the name, okay. But people have to be aware that they're voting or the use rights are going to be suspended on that meeting notice. Just be sure you're right and correct in what you're doing. However, with respect to voting rights, there was a case not too long ago regarding condominiums, which we think applies to HOAs as well, which provides that if your declaration was recorded before the effective date when the statute was amended to provide for voting right suspensions, which was in July of 2011, okay, then the authority to suspend voting rights must be set forth in your declaration, or your declaration has Kaufman language. What is Kaufman language? It says, your declaration says it's subject to Chapter 720 as amended from time to time. The reason that this case came about is voting rights are a substantive right. Okay, it's a vested right, and you cannot retroactively impose or impair someone's vested right. So that's why this case came about, saying that unless, the declaration was recorded after the authority to suspend voting rights was put in the statute, or if your documents incorporated those future amendments to the act, you have to amend your declaration to provide for voting rights suspension for those pre-July 2011 declarations. For suspension to take effect, written notice of suspension must be mailed, delivered again, or emailed to the owner and to the occupant or licensee or invitee. The voting suspension applies to the member. Interestingly, that last bullet point, a voting interest suspended does not count towards the total number of voting interests for any purpose. In other words, if you're voting on an amendment or something like that, that vote doesn't count. Okay. And it doesn't even count towards the quorum requirement. So if you have 100 lots and you've suspended the voting rights of, say, 2, 3, 4, 5 lots, whatever, those are now subtracted from the number needed to achieve a quorum or for the number achieved to pass any particular action. It's like they don't exist for voting purposes when their voting rights have been suspended. Hey, I reached the end.
Nice.
And I guess now, I want first of all, thank you everyone for listening, and Marita for helping me, and
Thanks, Peter. Great job.
giving me good
Appreciate
questions. I don't know, Jeffrey, if we're going to do some of the Q&A or how you want to.
Let's do this. Yeah, we have time for a little bit. We have
time it is.
we have some time left in the advertised time. So what I'm going to do is you and Marie to look over some of the pertinent questions. And folks, as I said in the beginning, we're not going to get to all of them. We'll get to several of them, but definitely not all of them. We have a lot of you here. We'll get to the ones that are more of the hard-hitting, more commonly asked ones, because the needs of the many outweigh the needs of the few, as we discussed previously. And while Peter and Marita are looking over some of the questions now, I am going to quickly remind everybody, if you haven't already done so, press the chat button so the chat area appears. Some of you already clicked the link for the evaluation and filled it out. But if you're clicking the chat for the first time, you will not have been able to see the link yet. So I'll put it in there once again. There you go. That's the, well, I forgot the F in folks, but there you go. The first word is folks, not oaks. So in the chat, you click on that link. It'll take you to the evaluation. You fill it out. After you submit the evaluation, you'll see a screen with Marita and Peter's contact information, as well as upcoming events, and a link to download and save today's slides, which many of you are asking about. After the Q&A, I will remain on to help any of you still struggling with that. So for now, I'll turn it back over to Marita and Peter to go over some of the questions. Back to you guys.
Peter, I'm going to give you an easy one.
Ah,
At least I think
famous
so.
last words.
If
What?
you mail the annual meeting notice, must you also post it on the website 14 days in advance of the meeting?
Yes.
Okay, if you mailed it and you post it on the website, do you still need to post it on site?
Yes.
I'll
Because they
take
missed
questions.
that in the
I'll take
question.
questions I could answer in less than a second for 500, Alex. Good job. Good job, Peter.
Yeah, the website is an addition to the other requirements. It's not in lieu of. Okay. So
Right.
you have to put stuff, you have to put your annual meeting or any membership meeting notices on the website at least 14 days in advance, but you still have to do the other.
Okay. And Marita, before you get to the next question, Fred asked something in the chat. Do we get credits now that it's done? As I mentioned earlier, I'll reiterate for those of you that might have gotten in a little bit late, but before the first slide, the required part is over. This Q&A right now is bonus time. So after you submit the evaluation, you can go. I mean, we want you to stay for the Q&A, but you don't have to. So submit the evaluation, then you can go. Then within 10 business days or less, your certificates are emailed to you to the address you entered on to the email address you entered on the evaluation. Back to you.
Okay, Peter, here's another one. For a general member meeting, not a special member meeting, how does an owner get an item placed on the meeting agenda?
You mean
So
for
it sounds
naming?
like they're talking about a regular board meeting.
Well, I'm not sure if they're talking about a board meeting or if they're talking about a membership meeting. If it's a membership meeting, there really is no way unless your documents have a process by which owners can do that. Okay. Which is pretty rare. Um, and even for a board meeting, unless I'm forgetting, and in the Condominium Act, there's a provision that you can petition to put something on a board meeting. I don't know why my memory is lapsing now. I don't think that provision is in Chapter 720 though, as far as owners having a right to petition for items on a board meeting agenda. That's my recollection. What else we got? No individual owner is going to get anything on an agenda unless the board allows it. There's nothing for that. Oh, you're muted now. Unless I muted you.
Can you hear me now? Oh,
No, I
sorry.
can. Yeah, I didn't hear you.
I can't believe the election proxies are permitted. By definition, they become part of the official records. Thus, I can find out how those proxies voted. What happened to one person, one secret vote? Okay, so this comes up a lot, Peter, that people don't like that they sent in a proxy and then someone can go and look at their proxy and see how they voted if it's a limited proxy for the election. But we've told them if there is nothing in the documents that prohibits that, when people vote by proxy and it shows who they voted for, if someone wants to look at that after the election, they have every right to come in and look at how their neighbors voted.
If those documents either require or permit limited proxy voting for elections,
Mhm.
then they're open to be seen. Uh,
The only way to get around it is if they
amend your
do a
documents.
right, or if it allows a ballot, they can do a ballot at a meeting.
Yeah, I mean,
But a
it's
lot of times with the proxy,
hard
it
for me to
doesn't.
answer that question, okay, without the documents. I'm not trying to cop out, okay, because I don't know whether in that particular association they should be voting by limited proxy, quite frankly, in their election or not. But if it's permitted or required and they want to stop that, then amend your bylaws to provide for secret absentee balloting, adopt a condominium style election by amending your bylaws.
And I'm going to ask you this question, and I'm going to grab my cord because my battery's low on my laptop. As a board member, this person wants to know if they can go to solicit. I know the answer, but I'm going to let you answer it. To solicit and obtain proxies. For example, if they go and ask their neighbors who have not voted and it's a limited proxy that they're using, are they allowed to do that? They have a vote coming up and they're concerned, I guess, about soliciting, getting a
You
quorum for their meeting.
you can knock on doors and get proxies. I mean, you can't coerce someone, you can't twist someone's arm, you can't fill out the proxy for them, but I'm not aware of any prohibition against soliciting or collecting proxies. I mean, that is one reason why the Condominium Act was amended 30 years ago to prohibit proxy voting for elections, but there's no prohibition from gathering proxies. Just you can't do it in a coercive type way.
This is where you talked about it was okay for us to let the board know what proxies we had in case they wanted to contact people who weren't coming to a meeting, so they could in fact get a quorum.
Yeah, I don't have an issue with that. You know, I don't have an issue with knocking on doors to get proxies. Again, if they're limited, no, you can't coerce people how to vote. As I mentioned when you stepped away, this was one reason why 30 years ago they amended the Condominium Act to get rid of proxy voting for elections, because it turns out there was like some shenanigans with people walking into meetings with 50 proxies, and controlling every election, and issues as to how did they get those proxies. So that's why they got rid of the proxy voting. But part of me wishes they would do that for HOAs, quite frankly. But they haven't done it yet. They haven't. So for the time being, yes, you can gather proxies. Yes.
Okay, is a ballot invalid or voided if the owner writes the wrong address, lot, or block number on the ballot? Well, it wouldn't be on the ballot, it would be on the envelope.
If it's a potentially, yes. I mean, if the name of the owner and the unit doesn't match, I mean, technically that would be a problem. I
Right,
mean,
and that should be picked up. I mean, when we have those come in, or if they turn them in at a meeting, we look at it to make sure, you know what I mean? If it's Mrs. Jones and Mrs. Jones lives at, 113 Oak Street, that has to match,
yeah,
or it's
yeah,
no
the
good.
name and the unit or the lot address. If it's an HOA, they on an absentee ballot need that needs to match. Correct.
If a membership lacks the members quorum, okay, this was a discussion I had with a board member actually at an annual meeting the other night. If there is no quorum, they wanted minutes taken anyway. We have in the past just taken notes of what happened at the meeting, just as notes, but not any meeting minutes.
Yeah, because there
Because,
isn't because no meeting occurred.
correct, right.
There are no minutes of a meeting, official minutes anyway, because there wasn't a meeting, because there was no quorum.
Yeah, and they're asking if a homeowner was appointed to the board to fill a vacancy at said meeting. Well, it wasn't a meeting, so that shouldn't have happened. They would have had to have a meeting to appoint someone.
That would have been at a board meeting though. If you're appointing to someone to fill a vacancy, it depends on how many board members are left. You know, you know, but
Oh, you're right. So if there's only two and three is a quorum, those two would appoint that third
yes,
person.
yes. Or if the whole board resigned but one, that one person could appoint.
They appoint it.
Yeah, so that would depend on the circumstance. It's the
See this.
majority of the remaining board they get to appoint.
Our governing documents do not address mail-in ballots. Neither allows it or restricts it. Can we use mail-in ballots for potential changes to governing documents if
No,
their documents don't allow it? I mean, that's a
no,
no. Yeah.
no. That's if your documents say you vote in person or by proxy, and there's no mail-in ballot process in there, then there's no mail-in ballot process.
Okay. Here's a good one, and I'm going to give you an example of something that we found in the documents. This person asked, what happens if there is a tie in voting at a meeting? And I have to tell you, we actually have an association in their documents that if it's a tie, they flip a coin.
Oh, I've seen
It's
that.
written in the documents.
I've written that in documents.
I have
Um,
never, I have only seen that in one association where they
a
talked about
tie
flipping
for
a coin.
election now? We're talking about a
Yeah,
tie.
tie. What happens if there's a tie in voting for an election?
Oh, an election? Okay. Number one, I typically ask either candidate if they want to step away. Not coercively, but I will ask. If there's a tie-breaking procedure in the documents, obviously you follow that. Okay. For condominiums, there's a statutory one. We're not talking about condos here, though. If neither, now this gets interesting. If you're doing a type of election where the people are voting in person or by proxy, okay, where you handed out ballots that evening, because then I would have the tie break election right then and there, right? I would have
And the people in the room vote.
I would have the owners vote right then and there for those two candidates to break the tie. If it's a procedure where there's mail-in voting, okay, in other words, you have a secret mail-in voting process, kind of like condos, I would notice another meeting to break the tie between those two. So it kind of depends upon the bylaws and how they do the elections, whether I would break the tie right then. Now, if you do have a document that says flip a coin, you flip a coin. Okay, that would control. Uh, Again, if it was just an old-fashioned type one where you vote in person or by proxy, I would do the tie break vote at that meeting.
Okay, here's a good one. So they have, apparently they're voting on a lawsuit and they're offering people $5 Starbucks gift cards in order to get them to vote.
I'd hold out for an Amazon card.
One thing, seriously,
Uh,
say it's an improper common expense. Okay. Uh, there's really no authority to be
Giving
paying
out gift cards.
paying people to vote or giving out gift cards. I would not do it for that reason. Uh, would it invalidate the election? I don't know. I've never heard of that craziness before.
Well, it sounds like this is a lawsuit they're looking to file, and they wanted people to, I guess, vote, I'm sure, towards this lawsuit.
Yeah, because the statute says, well, some documents say you have to vote for certain types of suits. Statute says you need approval when it's over $100,000 in controversy. I would not be buying votes.
Right.
You
I
don't
don't
want
think
to
that sits well
do
no matter
not want
what.
to make your vote subject to challenge later, okay, that your vote was invalid for some monkey business about buying votes. So I would not do that. I would 100% say don't do that. You're just going to open yourself to challenge.
Going to say, even if there's no legislation, you always want to err on the side of caution.
Yeah, you can't be buying votes. I mean, I think it's going to throw the whole thing into a challenge.
How
How
many
about
membership meetings? How many membership meetings does an HOA have to have per year? And how
one?
many board meetings do they have to have per year?
They have to have one membership meeting. Okay. The annual meeting. There is no minimum board meetings.
But they have to have an organizational meeting after their annual
Well, yeah,
members
okay,
meeting.
yeah. You have to have an
So it'd be
organization.
one.
Okay. And your documents, your bylaws may require for a certain amount of meetings. Okay. Condo Act was amended, but we're not talking about condos today. But oh, and they also have to have, I think also at that meeting, they have to talk about MARTA too. They have to mention during their first meeting about the requirements to preserve your documents under the Marketable Record Title Act. That can be done at the organizational meeting, or it's a crazy part of the statute. It doesn't really mean anything, but you still have to do it. Yeah, so yeah, the organizational meeting, unless your documents have some minimum, other requirement.
Are board members permitted to have group texts to discuss pending contracts? Again, I know some of these answers, but I'm throwing them to you, Peter.
Yeah, they can communicate with each other by email. I think they communicate each other by text. They can't vote that way though.
Does a person record?
Does that turn to a board meeting? I don't know. Maybe. I encourage my clients not to get into a, group real-time chat where it's like they're all meeting in a room, except they're meeting remotely through a real-time text. So I said no, they can communicate, but I wouldn't do it with a quorum or more in real time.
An
I'm
owner
just
has
reading through some of these.
there's a good one here at the end that's a quick answer. If an owner has multiple parcels, can that owner get more than one vote? Do they have multiple votes?
They most likely do under their documents. It's
Right.
usually one vote per lot.
There you
or
go.
whatever the voting allocation is.
But check your
Yes.
docs just to be sure.
Yeah, they pay multiple assessments and they get multiple votes.
Yep.
So this person said, if a homeowner or board members want something in the minutes, it is ultimately up to the secretary what is written in the minutes, question mark.
No.
No,
The secretary, the
and
secretary is more of a scribe, okay?
right.
He or she is taking the minutes. They're not deciding what's in the minutes, right? Uh, I mean, what goes in the minutes, again, there's no statute on this, but basically the minutes, as I said during the presentation, should reflect how many board members were there, is there a quorum, who made a motion, what was the motion, who seconded the motion, and what was the vote on the motion, and how did each director vote? Um, uh,
That's what I tell people, less is more.
yes, yes, but the secretary cannot either during the
Decide
meeting
what's
or
going
afterwards
in.
unilaterally amend or decide what goes in there.
Right.
So Marita and Peter, there's 4 minutes left in the advertised time. So pick one or
Okay.
two more questions, and then I'll stay on to help people with the evaluation if anybody's struggling.
Okay, the next one. Can members be required to wait until all agenda items are discussed, or may they speak during the board's discussion on an agenda item? So if the board's taking a vote on an agenda item, do they have to let the member speak then and there, or can they make them wait till the end of the meeting?
Okay. There's no specific law on this, but I heavily, heavily encourage you to allow people to speak on each agenda item before the board votes.
Right.
Otherwise, those comments are meaningless. Okay.
Yeah, it's the right thing to do. Otherwise, you
Right
just
thing
make
to
the people
do.
feel like they're not
Yeah.
important.
Don't make people withhold their comments until the end because the board's already voted. Okay. And I hope the statute gets amended sometime to expressly say this, but I always encourage all my boards very strongly. Okay. You allow owner comment as each agenda item comes up and before the board votes.
And
And I think
Danielle,
the other thing that is really important is in people doing that, have a 3-minute rule because you will get the board. Trust me, I've been in the meetings where somebody wants to read, their full page that's going to take them 5 minutes to read.
yeah,
And we encourage the boards to adopt a 3-minute rule. And if it's longer than 3 minutes, they need to put it in writing and the board will consider, whatever it is they're looking to discuss. Because usually that happens under the open items, not something that they're voting upon, but
yeah.
most of them have a 3-minute rule and we time them.
I agree 100%, 100%. Otherwise, you'll be there all night. Um, I agree. As I said during my talk, adopt reasonable rules regarding the frequency and duration of their statements. And I think 3 minutes is fine. Actually, 3 minutes is what you have. 3 minutes is what you have to do for member meetings, but I would adopt it for board meetings too.
Okay, I'm going to make this our last question. Is it correct that advisory committees cannot include a board member? Assume that a committee has been formed to select landscaping with a third-party landscaping company. Is that committee obligated to provide notices of the meetings with the landscaper to take minutes, and can a board member be on that advisory committee?
A
So it's
board
really 3
member,
questions.
okay, a board member can be on the committee. Okay, I have no reason to say why they couldn't. And that meeting does not have to be noticed and does not have to be open to the owners unless your bylaws require it to be, or unless for some reason that committee is taking final action, which would be unusual because it's an advisory committee. The answer is, in my opinion, yes, you can have a board member on there. But no, it does not have to be noticed and open if it's just advising the board.
And they don't have to take minutes. It's not a legal meeting.
Not have to take minutes. They may want to, okay.
Well,
Like,
they probably want to take their own notes, but I don't
yeah,
think in a lot of times they want to have something that they have to do in a board report
no, they
that's
say they
formal
don't have to.
minutes.
They could if they wanted to,
Right.
but they're not required to. I mean, they can issue a report, a written report to the board if they wanted to.
Right. Well, Jeff, I'm going to turn this back to you, but again, I want to thank you guys for doing this today. Jeff, you, Peter, and the firm for doing this for all the board members and owners who are on. Truly appreciate helping everybody get their required credits, and the fact that you do this for people who are not clients. And we try to branch out. So
Well, we
if you're
thank
having
you.
any issues with your management company, keep us in mind. And I definitely would keep Kay Bender Rembaum in mind if you're looking for an attorney.
Thank you, Marita. We appreciate it. Great job.
Yeah, thank you. Thank you for inviting us, Marita. Great job to you, Peter. Great job as always. And it's getaway day. I'll let you both skip out, and I'm going to hang out. And Peter, any parting words before you head out?
No, just thanks everyone for listening. I hope it was somewhat educational, somewhat informative. And everyone have a great weekend. Okay. Thank
Thank
you.
you. You too.